Hello everyone. This video is aimed at providing a brief introduction to the International Journal of Law in Context, which is published by Cambridge University Press. We would like to provide an overview of the purpose of the journal, as well as the scholarship that the journal aims to publish, and in this regard, explaining a little bit more the meaning of law in context. We hope that this will be helpful for prospective authors who plan to submit an article to the journal. I am Serena Natile, and I'm an academic at Warwick Law School, and I'm also the managing editor of the journal, which I joined in 2018. Today with me, I'm very delighted to have David Nalken, who is one of the historical editor-in-chiefs of the journal and is a professor of comparative and transnational law at King's College. Thank you so much, David, for being here. I would like just to start by asking you a question about the purpose of the journal and the meaning of law in context.
Thank you, Serena. And we do hope this will be useful to those of you who want a bit more clarity about what the journal seeks to publish and what it doesn't publish. If you go on our website, it says that the journal publishes contextual work about law and its relationship with other disciplines. Then it lists them, including but not limited to science, literature, humanities, philosophy, sociology, psychology, ethics, history, and geography. Well, that tells you maybe too little as well as too much, because it doesn't really explain, and we see this in some of the articles that are submitted to us, what contextual work means and relationship with other disciplines is getting at. And so our purpose in this video is to say a bit more about that. So in answer to your question, Serena, interdisciplinary work and putting law in its context is about trying to relate law to what else is going on in the world and to other approaches, we might call them other disciplinary approaches from other subjects like history or economics, to understanding what's going on in the world. So how is law working in relation to other things? And how would we know? The first question we might call the ontological question, what's going on in the world? And the second, the epistemological question, how do we know what's going on in the world? So getting down to the meaning of law in context, there's sort of two main meanings then. The first, which has to do with knowing what's going on in the world, is an article that will be suitable for the journal will relate whatever law you're talking about, to the larger social, economic, political, technological, or even religious developments that are behind the changes in the law or that are affected by that law, whether it be in the present or the past or even in the future. So law in relation to other larger, wider developments would be, yes, that's the sort of article that we're looking for. That's the first meaning of law in its context, law in its larger place in the world. The second meaning, which is equally of interest to us for the journal, relates law to other ways of knowing the world, other ways of studying the world, often on the same subject, the same topic that law deals with. Other people, other organizations, and above all, other ways of knowing, other disciplines have something to say. Whether you're talking about crime, what do the criminologists say? Whether you're talking about the environment, what do the geographers say? If you're talking about memory, what do the psychologists say? If you're talking about competition, what do the economists say? And so on. So an article which tells us, yes, we want to know about law, but tells us about legal developments and legal ways of looking at things, which themselves have to in some way keep abreast with, even if not always totally adopt, what is said about the same topics, the same problems, same issues by other approaches, that really is going to make us happy. So let's take a mainstream area of law that everybody studies in law school, the law of negligence. Well, if we take the first meaning of the law in context, law in relation to other things, it would be very useful to know, and people are beginning to tell us, the last generation, when the law of negligence offers a remedy, how does that remedy after a car accident or an accident at work, how does that remedy relate to the other remedies, the other answers, the other things that will happen, which rely on insurance or rely on, where it exists, government giving welfare payments? How do these things go together, interfere with each other, rely on each other? Often behind the person in court is an insurance company. So that is law in relation to what else is going on in the world, and it affects it, and law affects that. But the second way in which the law of negligence would be of interest to our sort of journal would be to ask questions about the way law decides and defines liability and cause and foresight and all the terms it uses in relation to what other subjects like economics or psychology or statistics would say about the same terms. Has law got it right if it doesn't use the same language or the same methods? Should it simply adopt these other approaches, and why or why not? So these really are the two approaches to law and context. Having said that, and I'll finish, it doesn't mean to exclude other ways of talking about law and context. One of the recent journal issues talked about what do we mean by context. So of course, a journal such as ours has itself to be open to being told that that framework that I've used is itself one that can be revised.
Thank you so much, David. And in fact, the journal tends to encourage new scholars in particular to engage with different disciplines, but also to use different methodological approaches in order to engage with this aspect of law and context that David talked about. Can you provide maybe some examples of recent articles which engage with the law and context, David?
Yes, Serena. I think anybody who would wish to submit an article to our journal or to any journal will be well advised to go and read and see what others have managed to succeed in getting into the journal. But just to sort of systematize a little bit the types of articles over the last 2 or 3 years that might be helpful, we can take the following categories. The first category would be to say, what is a social problem, a problem that causes concern in society, that people agitate about doing something about? What is a recent social problem about which an article could be written, or even a whole special issue in our journal? And examples of social problems in recent issues of the journal include what's called marginalization, who's being pushed to the margin of society, or relatedly, stigmatization, discrimination. So these are the sort of topics which a journal like ours is very interested in, because they're about law in the wider world, the developments in which new groups demand to be given consideration, and how far can law help them achieve that. A second category is more broadly looking from the other side, not what the problem is, but what can law offer? You know, what is law's role in dealing with issues in society? So we might look at human rights, indigenous rights. What ideas, what solutions is law developing, which then people in social movements can try and take advantage of. Thirdly, there are the organizations and the institutions of law itself and procedures through which any remedies have to pass to be considered legal ones. So we're interested in the legal profession, the role of prosecutors, judges, and the rest of it. And to see not so much recent legal changes in these organizations, but the larger forces that lead to the decrease in possibility of getting access to law, getting legal aid, and the implications of such changes for the remedies we've talked about. It's one thing to increase the rights that people are entitled to recognize new rights claims. It's quite another if at the same time, and it is happening at the same time, you reduce all the time the amount the government's willing to help people in bringing legal cases. And finally, because it would be a mistake to be too to be defining things too tightly. It's a journal which is generally trying to be open. So anything which comes under the heading of law and religion, law and epidemics, the recent COVID epidemic, law and immigration, law and technology, these are the sort of topics where we would be very interested to see people writing about them, because those are the sort of topics, as we've seen before, where one or either or both of these aspects of law and other approaches, law in society, will undoubtedly come into play. And trends change and times change, so that an article about law and economics and how economics is the crucial approach to look at is perhaps less timely than one about law and computer science and artificial intelligence. But a good article using either of those approaches is always welcome.
Thank you so much, David. And just a quick addition to this, from a more practical perspective, from the perspective of the editors receiving these articles, we are having a very high percentage of desk rejections at the moment, about 90%. And one of the key reasons for this is exactly because many of the articles we receive, they provide a description of a legal institution, of a legal concept, even in a particular country or context, broadly speaking, but they don't really engage with the broader social, political, economic, or technological context that David was talking about. And this is very important because we require this engagement in promoting scholarship on law in context, so socio-legal approaches, different empirical approaches, but we need this engagement and the broader literature and the different disciplines that David talked about. So a key suggestion is really, as David said, to look at the articles that have been published in the journal, but also try to contact the editors in case you have an idea, you are not sure about your approach. We are always very happy to help. And we know there have been delays with the reviews lately because since the start of the pandemic, but of course we are always very happy to answer in case you have an idea you want to check with us before submitting a journal. And of course read the instructions for authors on the website as well, which is also very important because of course allows us then, in case is a compelling argument, is a law in context article, to send it directly to the external reviewers. And of course the process of publishing is quicker if you do this. So thank you so much, David, for your insights. And we really hope that this will be helpful for prospective authors.
Thank you, Serena. Looking forward to receiving lots more wonderful articles.